Welcome everyone. Thank you for joining us on today's webinar. I am Nikita Singhal from Webtel, welcoming you to the second session on the practical GST case studies on real estate sector. So as we all know that we are living in the era of digitalization where everything from the simple to complex demands eases with technology. Here is why Webtel believes in making it a way of life. We are India's one of the leading e-compliance companies known for its compliance management, office management, and HR management solutions. We have incorporated a knowledge academy as well, where you can do all your learnings by opting for self-paced courses, staying in line with the blogs, keeping pace with webinars, etc. So let me introduce you to our speaker of the day. So our speaker is CA Tushar Aggarwal, who is co-founder of Tattvam Advisors. He has more than 10 years of experience in indirect taxation and has worked for more than 8 years with Lakshmi Kumaran and Sridhan attorneys. He was deployed by the GSTN for GST implementation and has closely worked with government officials. He has worked extensively with Government of India GST in designing GST returns, audits, and other formats. Now, before starting the session, let me give you a brief into about today's agenda. So, for ease of understanding, we have divided this series into two sessions. One part of which was held on May 27th. But in case you have missed it, you can access the same on Webtel's YouTube channel, and we will share its link also in the chat box. Today's agenda is to cover some of the very important topics, including concept of development rights and its taxability, GST implications in joint development agreements, area revenue sharing for commercial or residential projects, plotted colony, etc. Now, without further ado, we will turn the time over to our speaker of the day, CA Tushar sir. Sir, I welcome you to the session on behalf of Webtel. Please share your insightful knowledge on today's topic.
Thank you so much, Nikita and Webtel team, for the warm introduction. I will just share my screen.
Yes, sir.
Good evening, everyone. Friends, in the last session, we had discussed various case studies related to real estate sector, such as taxability of various charges collected on sale of unit to the customer, tax implication on cancellation of unit, sale of plots, so on forth. In today's session, we will be focusing more on joint development agreements and case studies related to input tax credit. So what do you mean by joint development agreements? Let's understand that first. In very simple terms, joint development agreement means an agreement under which two parties, namely landowner and developer, come together for development of a project. It may be a real estate project or a commercial project or a plotted colony, etc. Landowner contributes its land, developer contributes its construction skill, marketing skill, etc. They develop a project and then they sell the project in the market. They may share the area or the revenue as the case may be. So this is a collaboration between two different parties. What is area sharing agreement? What is revenue sharing agreement, etc. We will all discuss this in details in today's webinar. So, but before we start and drill down into it, why there is a need of a joint development agreements? First is because of land ceiling laws that developer cannot acquire land beyond a certain limit. Hence, he has to collaborate with the landowner, who is the owner of the land. Second is that there are so many farmers, etc., who are having land at a very good location, which can be commercially exploited, but they lack the resources. They don't have the expertise. So they want developer to pitch in, come in, collaborate with them, and ultimately develop the project, and they can accordingly share the revenue or the area. So that's why there is a need of joint development agreement. And in Delhi NCR, you will see numerous developers entering into joint development agreements in regular manner. So whenever a joint development agreement is drafted, the way it is drafted, you will see in the draft that it is specifically written that there are two parties. One is the landowner, second is the developer. Landowner contribute his land by way of giving of development rights. So landowner gives its development right, it contributes its land. The responsibility of construction, marketing, sale, everything is on the developer only. So whenever we read a joint development agreement, you will see the role and obligation of landowner is limited to landowner contribution, and role and obligation of developer is to undertake construction, perform legal formalities, market the project, sell the project. So these are the activities which the developers undertake. And then whenever the building is constructed, they either share the area. For example, if 100 units are constructed, 60 will belong to the developer and 40 will belong to the landowner, or the responsibility of sale is given to the landowner, the developer sells entire 100 units in the market, and then they share the revenue. These agreements are not in the nature of association of person. It does not result into an AOP, because the role and obligation and risk and reward of landowner as well as developer is properly divided. Landowner role is limited, that is giving of development rights, giving of land. Developer's role is limited to construction, marketing and sale, and then they share the revenue or the area as the case may be. It's not sharing of profits, etc., which results into AOP. The risk and reward are perfectly divided. So we have to be very sure whenever we are drafting a joint development agreement, we have to make sure that it does not result into an AOP. So again and again, this term which I am using, that in a joint development agreement, landowner gives the development rights to the developer so that developer can develop the project, market, sell. So what do you mean by this development right? What is the nature of this development right? What are the attributes of this development right? Friends, development right, very important, is a right to construct, own and sell the superstructure. This is the right which is given by the landowner to the developer. Whenever landowner is owning a particular piece of land, he is having various kinds of rights over that land, right of ownership, right to construct, right to sell, etc. So what he gives to the developer is only certain bundle of rights, which is a combination of right to construct, right to own, or right to sell the superstructure. The ownership right is never given. The ownership right always remain with the landowner only. So the developer, the landowner, what he actually do, he separates the development potential of the land, and this development potential of the land is transferred to a developer, and this development potential, that is right to construct, own and superstructure, is nothing but in the nature of profita prendere. This is nothing but an intangible immovable property. So friends, in pre-GST era, we have various kinds of judgments which have dealt with the concept of development rights. And in all these judgments, what has been held is that these developments are nothing but benefits arising out of land. This right to construct the building, own that building and sell that superstructure. That development right, that TDR, is nothing but a benefit arising out of land and is considered as an intangible immovable property. I repeat, this development right is nothing but an intangible immovable property. We have Bombay High Court in the case of Chadda Housing. We have Shakti Insulted Bias. There are various judgments wherein it has been consistently held that this is in the nature of intangible immovable property. So in a joint development agreement, first of all, the landowner executes a JDA. They also execute a power of attorney. The landowner give power of attorney in the name of developer so that developer can take all the permission, execute conveyance in its own name, etc. So these two documents are always executed. Developers develop the entire project, sell it in the market and share revenue between the parties, or the area between the parties is shared. And the conveyance is always executed by the developer and landowner together. So before we drill down into the tax implications of various kinds of joint development agreements, let's first understand what is the taxability of this development rights which are given by the landowner to the developer. Whether there is a service tax or GST on sale of or transfer of development rights by landowner to the developer. Let's understand this. In service tax regime, the definition of service read as under, I am reading for the benefit of all. Service means any activity carried out by a person for another for consideration and includes a declared service, but shall not include an activity which constitutes merely a transfer of title in goods or immovable property by way of sale, gift, or in any other manner. So, transfer of title in immovable property by way of sale, gift, or in any other manner was outside the ambit of service tax. So if my joint development agreement was entered prior to 1/7/2017, that is before GST came into picture, then I will have to look at the service tax provision, and we have to look at this service definition which was there in Finance Act 1994. Friends, please note, in a real estate project, the life of a real estate project generally varies from 3 years to 7-8 years. It may so happen that your JDA is entered in 2015, but today you are allocating the area to the landowner. Today also you are getting the revenue share as a landowner, even though your agreement was entered in 2016, 2015, etc. So we have to be aware about the provisions which were prevailing before GST came into picture, that is the service tax provisions, and you are also have to be cautious about the GST provisions which are existing before 1/4/2019 as well as after 1/4/2019. Because it may so happen that my agreement is entered on one date, whereas area sharing and revenue sharing is undertaken on any other date. Hence, we have to see the agreement cumulatively consisting of all the tax periods. So what I am discussing is on the taxability of development rights for an agreement which is entered before 1/7/2017. So if an agreement is entered before 1/7/2017, landowner is transferring development rights to the developer, whether there is a service tax implication, for which we are referring to this service definition, which specifically excludes transfer of title in immovable property by way of sale or gift or in any other manner. Friends, we have already discussed that development right is nothing but an intangible immovable property. So immovable property can be tangible immovable property or intangible immovable property. Intangible immovable property means benefits arising out of land, like development rights, like leasehold rights, etc. So in this particular example, if I am transferred the development rights in pre-GST area, then to my mind, it's a very good case to say that it is nothing but a transfer of title in immovable property, and hence the same is excluded from the definition of service, and hence no service tax will be leviable on this. We have a landmark judgment in the case of DLF Commercials Projects Corporations, although by Honorable Tribunal Chandigarh, wherein it was held that there is no service tax on transfer of development right, as it is nothing but a transfer of title in immovable property. However, an important point to be noted is that in India, any immovable property can be transferred only through a conveyance deed. Section 54 of the Transfer of Property Act deals with transfer of immovable property. It may be tangible immovable property, it may be intangible immovable property, and it says that any immovable property can be transferred or sold only through a registered conveyance deed. So if my development agreement is registered, if I have entered in it into before 1/7/2017 and the same is registered, in such a situation, this transfer of development right through a registered joint development agreement, no service tax applicable, a very good case to say. Today also many show cause notices have been received by the developers and the landowners on this particular point, but if their agreement is registered, then it will be a very, very strong case to argue that no tax is leviable on this particular transaction. However, if the agreement is not registered, then it will be a gray area and interpretational issue will come into picture. Moving towards the GST regime. If my agreement is entered after 1/7/2017, but before 1/4/2019, what is the taxability of the development rights which are transferred by the landowner to the developer? Friends, if we compare the law which is there in GST regime, under GST, if we see Schedule 3, it specifically says that these are the activities which neither will be considered as supply of goods nor supply of services. And one of the activity at paragraph 5 is sale of land. So what is excluded in GST regime is sale of land. Whereas what was excluded in pre-GST regime was transfer of title in immovable property by way of sale. So there the words used was transfer of title in immovable property. Immovable property can be tangible or intangible. Whereas the words used is sale of land. What is excluded in GST regime is sale of land. So whenever a landowner is transferring development rights to the developer, is he selling land to the developer? Is it a sale of land? Section 54 of the transfer of property says sale of land can occur only by way of registered conveyance deed. I never sell my land to the landowner. The right of ownership always remain with the landowner. I never sell it to the developer. I never convey a conveyance deed in the name of the developer. What I give them is only a development right. That is a limited right to construct, own the superstructure and sell the superstructure. Ownership of the underneath land remains with landowner only. I repeat, ownership of the underneath land remains with landowner only. So in such a situation, if we have to argue that transfer of development right will be treated as sale of land, then it will be very, very tough in my view. In my view, sale of land is a restricted phrase vis-a-vis what was specifically used under pre-GST area. In pre-GST, the language was very wide, transfer of immovable property, any immovable property, whereas the language in GST is sale of land. Accordingly, in my view, after 1/7/2017, in respect of joint development agreements, all these agreements, whichever are entered after 1/7/2017, transfer of development rights by landowner to developer will be leviable to GST. These are not excluded under Schedule 3 because of the phrase used is sale of land instead of transfer of immovable property. Secondly, the taxability before 1/4/2019 on development right was on the landowner. So it was landowner who was liable to pay GST on this transfer of development rights to the developer. However, after 1/4/2019, there has been a paradigm shift. We discussed in our phase 1, part 1 also that the tax rates as well as the exemption provision and reverse charge provisions for real estate sector has undergone a wide change. Now, after 1/4/2019, there is no tax liability on landowner. The concept of taxability of transfer of development rights is now covered under reverse charge mechanism. So tax, if any, on transfer of development rights will be paid by the developer under reverse charge mechanism after 1/4/2019. So to conclude, if my JDA is entered before 1/7/2017, if it is entered in service tax regime, then in such a situation, there is no service tax on transfer of development right. It is a very good case to argue. Second, if my JDA, joint development right, development agreement is entered between 1/7/2017 till 31st March 2019, between this period, then there is a GST liability on transfer of development right, and that GST liability is on the landowner. It is in the hands of landowner. Landowner is liable to deposit it to the government. For joint development agreements which are entered after 1/4/2019. So all these agreements which are entered after 1/4/2019, the taxability of development rights, there is no tax in the hands of landowner. Taxability is under reverse charge in the hands of developer. Further, there are certain exemptions which we will discuss in later part of the slides. So after 1/4/2019, no tax liability in the hands of landowner. The entire entry of transfer of development rights is now covered under reverse charge mechanism. So tax, if any, has to be paid by the developer under reverse charge mechanism. So this is the sum and substance of the entire taxation of development rights. And before we proceed further, one important aspect which is yet to be settled and we must be aware of is that whatever landowner is receiving for transfer of development rights, see, I am getting 40% revenue share. Say there is a project, 100 crore rupees is the revenue of the project. I gave development rights to the developer. Developer sold this project for 100 crore rupees, sold all the units at 100 crore rupees, and he gave me 40% revenue share. So what landowner received is 40 crore rupees. The issue is that in service GST, there is a GST implication, tax implication on this 40 crore rupees, which is received by the landowner. Say this agreement was entered in July 2017 only. The issue which really these days is coming up and is a matter of debate is that whether entire 40 crore rupees is for transfer of development rights. Ultimately, what will happen? I have given development rights to the developer, but ultimately the ownership of the land, once this builder constructs the unit and I give power of attorney to the builder, builder conveys the superstructure along with the underneath land to the end customer. So once the project is completed, the ownership of the land goes out from my pocket to the pocket of the ultimate buyer, ultimate customer. So if I am receiving 40 crore rupees, is it only for development of development rights? will not it be attributable also towards the ownership of the land which I am having it and which is ultimately conveyed to the customer? The answer is yes. The amount which the landowner gets is attributable towards development right as well as towards the land which is conveyed by him. So we have to vivisect this amount into these two parts, but departmental at ground level never agrees with this. So this is a point which we all have to keep in mind, that the amount which is received by the landowner is not only towards development rights, but also towards the land which is ultimately conveying. And there cannot be any tax liability on the conveyance of the land. So we have to bifurcate this amount into development right consideration as well as the consideration towards the sale of land, which is ultimately there. Now, with this in background, let's discuss the tax implication from landowner as well as developer's perspective in respect of joint development agreements which are entered after 1/4/2019.
Tushar, sir, your voice is breaking in between.
Is it audible now? Is it audible now?
Yeah.
Okay. Now let's proceed further to discuss the tax implication on landowner as well as developers in case of area sharing as well as revenue sharing agreement. For the benefit of all, what is area sharing agreement? Landowner transfers the development right to the developer. Developer develops the project. Say he has developed 100 units. Developer retains 60 units and then he transfers 40 units to the landowner. So landowner sells its 40 units in the market and developer sells its 60 units in the market. That is called area sharing agreement. Moving on towards revenue sharing agreement. In case of revenue sharing agreement, landowner transfers the development rights to the developer. Developer develops the project. Developer only sells the entire 100 unit in the market. Say this 100 units are sold for 100 crore rupees. 60% say is the revenue share. So 60% is retained by the developer and 40% is given to the landowner. So that is called revenue sharing, in which landowner gets the revenue of the units sold by the developer to the end customer, whereas in case of area sharing, the landowner gets the area which is constructed by the developer. An entire tax implication is dependent upon the fact whether my project is REP project or RREP project. Friends, if you recall, in part 1, we have discussed this concept. RREP refers to a project. The RREP means residential real estate project, which refers to a project in which carpet area of the commercial apartment is less than or equal to 15%. RREP, residential real estate project. So in a real estate project, if I am building 1 lakh square feet, out of which 90,000 square feet is residential project and 10,000 square feet is commercial project. So this 1 lakh square feet project will be treated as RREP, residential real estate project. Second as is REP, that is real estate project other than residential real estate project. REP refers to a project in which commercial area is more than 15%. So in a project, if your 50% is residential, 50% is commercial, that is called REP. Similarly, even if 100% is commercial, that is called REP. So we will discuss this term again and again in subsequent slide, RREP and REP. Everyone, please learn, please remember this concept. Let's take first case study. Residential real estate project, RREP. That is a project in which residential area is more than 85%. Say in our case, say 90% is residential area and 10% is only commercial area. And this has to be seen RERA wise. This RREP and REP bifurcation is not license wise. It is RERA wise. Please remember, most important. So let me take an example. I have transferred the development rights to a developer. He will build a residential real estate project. He will build 100 units. 90 will be residential units. 10 will be commercial units. He will sell this entire 100, and we are discussing revenue sharing arrangement. So in case of RREP, what we are discussing is a revenue sharing arrangement. So this developer will sell the entire 100 units to the end customer, and I will get 40% of the revenue, which is realized by the developer. And for the benefit of we are assuming that developer is selling this unit at 1 crore rupees per unit. So ultimately he's getting 100 crore rupees as realized value, out of which I will get 40 crore rupees. On sale of units to the end customer, it's clear. The rate of tax for residential unit is 1% or 5%. If it is affordable, 1%. For non-affordable, 5%. For further, commercial units are also 5% in case of RREP. So sale of units are chargeable at these respective rate. Second is, any taxability in the hands of landowner? No, since it's a project which is executed after 1/4/2019, no taxability in the hands of landowner. Moving, so that entire 40 crore rupees which is received by landowner is not supposed to pay any tax on this. I repeat, landowner is not supposed to pay any tax on this. Third, what we discuss is that development right is covered under reverse charge mechanism. Developer has to pay the GST under reverse charge mechanism. So in case of RREP, there is an exemption available to the extent of sold units. So a developer is liable to pay reverse charge only in respect of unsold residential units. So in our example, the developer had built 100 units. 90 was residential, 10 was commercial. So out of this 90 residential units, he has sold 80 units till the time of OC. So there is no reverse charge liability on developer to the extent of this 80 units which he is selling. However, with regard to the unsold area, that is 10% residential units which remains unsold, developer at the time of OC has to pay under reverse charge mechanism GST, and the maximum tax liability which is there on this development rights under reverse charge mechanism on the unsold unit is equal to the market value of the unsold unit at the time of OC into 5%. That is the maximum tax which the developer has to pay under reverse charge mechanism. So in our example, out of 90 residential units, 10 remain unsold. So on these 10 units, the market value of this 10 unit into 5%, that will be the tax liability in the hands of developer at the time of OC. And also note that he will not be in a position to take input tax credit of this, because input tax credit is barred in case of residential project. With regard to the commercial units, 10% commercial units, again, there is a reverse charge liability on the developer. Developer, even for this 10% commercial units, even if you have sold it in the market, it's not remaining unsold, it does not matter. On all the commercial part in a RRP, this 15% commercial part, 10% commercial part, there is a RCM on developer. Developer has to pay under reverse charge mechanism, and the maximum tax liability will be market value of the flat into 5%. Practically, many of the developers are not paying tax, but the way exemption notification is drafted, it only gives exemption to the residential units which are sold under before OC. It does not give any exemption to commercial units. Hence, in case of RREP project, developer is liable to pay under reverse charge mechanism also on the commercial units which are constructed by him. And again, he will not be in a position to take credit. However, at ground level, 80-90% builders are not paying tax on this particular element, even though the exemption notification is against us. So CREDAI and many other organizations have also given representation to the government of extending this exemption to commercial unit also in case of RREP. Now let's move to second project. Say I'm constructing a commercial project. So what we discussed in the first case study was revenue sharing arrangement for a residential project in which commercial area was less than 15%. Now, second case study, what we are discussing is a commercial project. It's a 100% commercial project, revenue sharing. What will be the tax implication on this? I transfer development rights to the developer. Developer is developing 100 commercial projects, commercial units. These 100 commercial units will be sold at 1 crore rupees per unit, equal to 100 crore rupees revenue. Sale of these units will attract 12% GST. So whenever developer is selling these units to the end customer, he will charge effective rate as 12%, and he is also eligible to take input tax credit of whatever input he is getting it. Out of this 100 crore rupees, I as a landowner get 40% revenue share. So I have received 40 crore rupees from the developer as revenue share. There is no tax liability in the hands of landowner. Landowner is not supposed to pay any GST on this 40 crore rupees which is received by him. Third, reverse charge implication on developer. As we discussed, transfer of development right is covered under RCM. So developer is liable to pay under reverse charge mechanism on this 40 crore rupees, which is paid to the developer has to pay 18% GST on this 40 crore rupees, which is paid to the landowner. So this revenue share, which is received by the landowner, there is a tax implication in the hands of developer. Developer has to pay GST at the rate of 18% on the 40 crore rupees, which is given to the landowner under reverse charge mechanism for procurement of development rights. So there is an RCM liability on the developer. And when do the developer has to pay the tax? Legally speaking, tax has to be paid at the time of entering into an agreement, because my point of taxation arises at that time. So practically what the industry is doing is that they are developing the agreement in a manner wherein they are treating this activity of landowner of transfer of development right as a continuous supply of services. They make an agreement in such a manner that the role and obligation of landowner goes beyond 3 months. It's not a one-day activity of transfer of development rights. He also support you in blah 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 activities, so that his roles and obligation are there for more than 3 months, which result into making his services as continuous supply of services. In such a case, the reverse charge liability will arise as and when you will be making payment to him, so that you can postpone your RCM liability. So that's the practical solution which industry is doing these days. So to conclude, in case of commercial project, sale of unit by developer, 12% GST, whatever revenue landowner is getting, 100 crore is the sale value, 60 is retained by developer, 40 crore he gives to the landowner. No tax liability in the hand of landowner, but developer has to pay under reverse charge on this 40 crore rupees at 18% GST, and it is fully creditable. Moving on to the third case study. It's a mixed project. I am a landowner. I have transferred the development rights to the developer. Developer will develop 100 units. 50 units will be residential units and 50 units will be commercial units. So in case of a mixed project, the implication will be same what we discussed earlier. For the commercial units, the implication will be same what we discussed for the commercial project, and for the residential unit, implication will be same what we discussed for the RREP project. So this will be the tax implication in case of revenue sharing agreements. So what we have covered till now is revenue sharing agreement for residential project as well as commercial project. Now we will move towards area sharing agreements, wherein landowner is getting area from the developer. Let us take an example. I am a landowner. I transfer development rights to you. You are a developer. You develop 100 units. Entire 100 units are residential units. So it's an RREP project. It's a residential real estate project. Out of this 100 units, you will give me and allot me 40 units. So I will get 40 units from you, and remaining 60 units will belong to you, and you will sell it in the market and keep the money which you got from sale of those 60 units. And 40 units which you have allotted to me, I will sell it in the market and keep the money from sale which I have realized. So this is an area sharing agreement. So let's analyze the tax implication on various transactions which are involved under these kinds of joint development agreements, area sharing agreement for a residential project. The first transaction is sale of units to the end customer by the developer. So in our example, the 60 units which is retained by the developer and he sells to the end customer, he will charge rate as applicable on these units. 1% for affordable, non-affordable 5%. Second, developer is allocating 40% area to the landowner. Developer is allocating 40% area to the landowner. On this allocation of area to the landowner by the developer, there is a provision of construction services by the developer to the landowner, because he is constructing for the landowner and allocating 40 units to the landowner. So there will be a tax implication on this 40 units also, which is allocated to the landowner. Developer will charge GST at market value of these units, which is nearest to the first sale. GST will be leviable at the rate of 1% or 5%, as the case may be, affordable 1, non-affordable 5. And time of supply is any time before OC. So developer can pay tax not at the time of allocation, but at the time, any time before obtainment of OC. So if I have done allocation today, but OC is received after 4 years, my tax liability arises at the time of OC, and I can discharge before that. The tax liability is not at the time of allocation to the landowner. So there will be a tax implication on developer on this allocation to the landowner, 5% GST, market value of the nearest flat will be the value for discharging GST, and he can pay GST anytime before OC. And whatever GST he is paying, commercially he has to agree. Very important, most important, and the most important point which we have to keep in mind. Who will bear this GST liability? Developer has to pay it to the government, but can developer recover it from the landowner? Because these 40 units are allocated to me. So it is a commercial decision. If you write in your agreement that this GST will be borne by the landowner and landowner will give it to the developer, then landowner has to give. Sometimes it is shared as 50-50. So you have to write in the agreement that who will be bearing this GST on this allocation which is done to the landowner. That has to be specified in the agreement. I have seen more than hundreds and hundreds of joint development agreements, and most of the agreements miss out this point that who will bear this GST liability. So whatever new agreements we are undertaking, please write specifically who will bear this GST liability on allocation to the landowner. So landowner, whatever GST he pays to the developer, he can take credit if I am further selling it to the customer. So landowner will be in a position to take the credit of this if he further sell it to the customer. So that's the second transaction, allocation of units to the landowner. The third transaction is transfer of development rights from landowner to developer. No tax on in the hands of landowner. We have already discussed there cannot be any tax liability in the hands of landowner for transfer of development rights. Fourth, whether there is an RCM reverse charge liability on the developer on this receipt of development rights. So to the extent of sold units, there will be no RCM applicability on developer. It's only on the unsold unit. RCM has to be paid by the developer. Friends, please note this RCM liability on developer in case of residential project is only on unsold units, and in case of commercial project is on 100% units. I repeat, this RCM liability on development rights in case of a residential project is only on unsold units, and in case of a commercial project is on entire 100% units. So in our example, if out of 100 units which the developer has built, 40 he has allocated to me, so that will be deemed to be sold units. He has retained 60. Until OC he has sold only 55 units. So on the 5 units which are remaining unsold, developer has to pay under reverse charge mechanism at the time of OC, and this value will be the market value of this unsold unit at the time of OC. So on that he has to pay under reverse charge mechanism. Now moving towards the commercial project, the next case study, area sharing agreement for a commercial project. What will be the tax implication on this? Again, an example, I am a landowner, I am transferring development rights to the developer. He will construct 100 units, commercial units. He will give me 40 units as allocation, 60 he will retain and sell it to the end customer. So on 60 units which is selling to the customer, he will charge GST, effective GST at the rate of 12%. And he is eligible to get full input tax credit on its input. On allocation of unit to the landowner, again, there is a GST liability. Developer is liable to charge GST at the rate of 12% on the market value of these units, which is at the time of first sale of these units. Whenever I start my project, so whatever is the market value of my units, based on that, he will charge GST on the landowner and deposit it to the government. And when he has to charge GST anytime before OC. So developer can charge GST anytime before OC, what we discussed for residential project also. Landowner will be in a position to take the input tax credit of this GST, which is paid to the developer, provided if he further sell these units to the end customer. If landowner is not selling these units to the end customer, say he is leasing it out, in such a situation, it will become cost to the landowner, and commercially both the parties have to decide who will bear the GST on this. Now moving on towards the third transaction is of transfer of development rights. So when the landowner has transferred this development right to the developer for this commercial project, no GST on the hands of landowner, but there will be an RCM in the hands of developer. So developer has to pay under reverse charge mechanism on this receipt of development rights GST at the rate of 18%. And what will be the value? Value will be very important. Please note the value of development rights received by the developer on which he has to pay at 18% will be the value of units which I have received as a landowner. So I have transferred the development right for which I am receiving 40 units. If the commercial value of these 40 units is 40 crore rupees, then he has to pay 18% GST on this 40 crore rupees, and he can take input tax credit. So practically, that as per the law, the tax liability will arise at the time of OC. But practically people pay before that on under a reverse charge mechanism, so that they can take credit and utilize it towards their output liabilities. So there is an RCM on the developer at 18% on the market value of the goods which is received by the landowner, because I'm giving a development right for which I'm receiving 40 units. So this 40 units market value is deemed to be the consideration for the development rights which I have transferred to the developer, and developer has to pay under reverse charge on this particular transaction. Now with this, what we have covered is the tax implication in case of revenue sharing agreement as well as area sharing agreement, both for residential project as well as commercial project, both in the hands of landowner as well as developer. Now what we will do is that we will take certain case studies with regard to the transitional situations. What if my development right agreement is entered in pre-GST era and my revenue sharing is done in GST area, or area sharing is done in GST area? What to do, whether tax is payable or not? So let me take few examples. There can be so many transitional issues, etc. So I've taken 2-3 case studies for the benefit of all to understand this in detail. First case study, the joint development agreement is entered in 2010. I transferred the development right to the developer in 2010. However, the developer has not constructed the project. There was a delay. He started constructing the project only after 2016. And he is also constructing it till now, and all the area allocation or the revenue allocation is being done in GST regime. So the first issue is, whatever revenue I'm getting as a landowner in GST regime for a JDA, which I have entered in 2010, I have transferred the development right in 2010, but I'm receiving the revenue from the developer in 2018, 2019, 2020, because he is doing construction in 2019-20 and selling the units in 2018-19. Whether there is any tax implication on the revenue received by the landowner, the answer is no. Since my underlying supply has taken place in 2010, at that time it was nothing but a transfer of immovable property. Therefore, there was no tax liability on transfer of development rights. Accordingly, whatever revenue I'm getting it now, there will be no tax liability in the hands of landowner. What about the area? If I'm getting the area today, if landowner developer is giving the area today to me, in such a situation, legally, you can take an argument that the developer is not liable to pay GST on the area allocation done by them today in respect of a JDA which was executed in 2010, because for area allocation, whatever area developer is giving to me, he has received the consideration in form of development rights in 2010 only. So tax, if any, has to be paid in 2010, and since it's a time barred situation, so there is no tax liability. That argument can be taken. But practically what we have seen is that if you take that argument, then you don't have to pay GST on the allocation of the units to the landowner today in respect of a JDA which is executed in 2010. However, since you will not be paying output tax, you will not also be getting the input tax credit, and you have to reverse the proportionate input tax credit. So, and department at ground level also generally don't agree with this. So we have seen practically developers are paying GST on the allocation. If they are doing it in GST regime, they are paying GST and taking credit. Another example, my agreement was entered in 2018. I transferred the development rights in 2018, and it's a revenue sharing agreement for the sake of discussion. And I, as a landowner, I am receiving the revenue today also in 2019, 2020, 2021. What is the GST implication on this? Please note, after 1/4/2019, the RCM, the taxability of development right is under reverse charge mechanism. Developer has to pay under RCM. Whereas before 1/4/2019, it was under forward charge mechanism. The landowner was supposed to pay under forward charge. Now, in our example, it is landowner who has taken, it is landowner who has transferred the development rights in 2018. So the taxability will arise in 2018 itself. It's a transaction of forward charge mechanism. The tax liability will be in the hands of landowner only. Developer is not required to pay under reverse charge, even if they are sharing the revenue in 2021-22. The tax liability, if any, is on the hands of landowner only. So it is only if the JD is entered after 1/4/2019, then you have to go under reverse charge mechanism. And I'm giving you very broad examples. The exact implication has to be seen agreement wise. So it cannot be generalized. I'm just giving you an overall framework for the better understanding of the provisions, but it cannot be finalized. moving on towards the next case study is of taxability of in case of revenue sharing and area sharing of plotted colony. So I will take two examples. First example, I'm a landowner and you are a developer. I give land to you, you develop the plotted colony. That is the common area, sewerage system, water system, and gardens, etc., etc. You develop the plots, and then ultimately 70% plots are retained by you, and 30% plots you allocate to me. You sell your plots to the customer, I sell my 30% plots to the customer. On sale of developed plots, we have already covered in part 1 that GST implication that these are disputable matter, and practically these days whenever the plots are sold to the customer, many builders are charging development charges separately. They say 90 lakh is for the sale of plot, 10 lakh is development charges. They pay GST on development charges to avoid any dispute. Otherwise, sale of developed plot not liable to GST. Good case to argue. Now, what we are discussing is the tax implication on the collaboration agreement between the landowner and the developer. So we are taking the case of a area sharing, wherein the developer has developed the plot and he is sharing area to me. In second example, we will take a case study where he is selling the plot and sharing revenue with the landowner. So what will be the tax implication? Friends, if you see the GST provisions which have come up after 1/4/2019 for various joint development agreements, those provisions are applicable only for commercial projects as well as residential projects and not for plotted colony. I repeat, all the provisions which are there in the GST law for joint development agreements, whether under RCM provisions, whether under exemption section, wherever, it is only for commercial units or residential units, and nothing is there for the resident normal plots, whether commercial plots or residential plots. For plots, nothing is there in the law. So the first question always arises whenever landowner asks the developer to develop the plot and share the area or the revenue, is there a transfer of development right from the landowner to the developer? I've practically seen that many people get confused and they say that there is a transfer of development rights from the landowner to the developer, that I'm giving the development rights. Friends, there is no concept of development rights in case of plots. See, in case of plots, he is not developing any building and owning a superstructure. What he is doing is just building and constructing a common area, which is ultimately handed over to the authorities after 5 years. So he is not developing and owning a superstructure, unlike in case of high rise. What we discussed earlier, what is development right? Development right is a right to construct on the superstructure and sell that superstructure in the market. And in this case, he is not constructing anything on the plot. He's not owning something on the plot, and he's not selling something on the plot. What he's constructing is only the common area to make the colony viable for living and sell the developed plots without any superstructure. So there is no transfer of development rights by the landowner to the developer. In fact, landowner remains the owner of the land. Developer is only acting as a contract provider. What he is doing, he's just providing a services of construction of the common area, marketing of the project, and facilitating the sale. So in my view, in case of a joint development agreement for a plotted colony, there is no transfer of development rights from landowner to the developer. Rather, it is the developer who is developing the project, providing the construction and marketing services to the landowner. So in our example, in case of area sharing agreement, whenever developer, in our example, what developer has done is he has constructed the common area, undertaken the marketing, etc. He is sharing 70% plots are retained by the developer and 30% plots are given to the landowner. So on this allocation of 30% plots to the landowner, there will be a tax liability in the hands of developer. Developer has to pay GST on this 30% area which is given to the landowner. Valuation can be the value of the 70% land which is retained by him, undeveloped land which is retained by the developer, or cost plus 10%, whatever can be the mechanism. Based on that, the developer has to charge GST. I repeat, in this case, there will be no tax liability in the hands of landowner. Rather, it is the developer who is providing development services to the landowner, and on this development services, he has to pay GST. Moving towards the area sharing agreement, and it's the most controversial agreement. So in area sharing agreement, landowner gives the land to the developer. Developer develops the common area, makes the plot viable for sale. He obtains power of attorney from the landowner and then sell it in the market. Under the power of attorney which he has received. Out of sale of 100 crore rupees, he retains say 70 crores and he gives 30 crore rupees to the landowner. there are various advanced ruling like Maruk, etc. What they have said that developer is not selling land to the end customer, because developer is not the owner of the land. It is the landowner who is the owner of the land. It is only the power of attorney which is obtained by the developer, and sale through power of attorney is nothing but an agency sale. Supreme Court in the case of Suraj Lamp has specifically held that any purchase and sale of land can only be through an immovable conveyance deed. And in this case, if I am getting the ownership of the land, it can only be through a conveyance deed, and conveyance deed is never executed in the name of the developer. He only obtain a power of attorney, act as an agent of the landowner. So there are various advanced rulings which have held that in this case, developer is providing construction and marketing services to the landowner, and whatever amount he has retained, 70 crore rupees, there will be an 18% GST on this 70 crore rupees. So it's a highly debatable issue going on, and we always advise our clients to refrain from entering into a revenue sharing agreement. In case of a plotted colony, always enter into an area sharing agreement. That is most viable agreement for a plotted colony. With this, we have covered the joint development agreements, both for commercial, residential, and plotted colonies. And before we end our session and move towards the question and answer, I will be taking up 1 and 2 small case studies related to input tax credit and the emerging issues which are there in real estate. So one of the most important issue being faced under real estate is respect of the reversal of unsold unit. So let me take an example. I've started constructing the project in 2015, and I started taking service tax credit at that moment of time. And then when GST came, I took GST credit also. Now in 2022, out of 100 unit, I have sold 66% area, and 33% area remain unsold. The issue is whether on the unsold area, is there a liability to reverse my input tax credit which I have availed in GST regime? Second, whether there is a liability to reverse input tax credit which I have availed in service tax regime, send-back credit which I have availed in service tax regime. Am I liable to reverse it today if I'm getting an occupation certificate today? So under GST rule 4243 deals with reversal of credit, and the law is very clear. Law simply says that in GST regime, whatever GST credit you have availed from 1st July 2017 till date of OC, you have to reverse under based on unsold area proportion. So let me take an example for the benefit of all. Total cost of the construction of the project was 100 crore rupees. In service tax, I took credit of 10 crore rupees, and in GST, I have taken credit of 3 crore rupees. Date of OC is 31st/3/2019, and on the date of OC, 33% area remain unsold. So my GST law is very clear. Whatever GST credit I have taken, that is 3 crore rupees in this example, I have to reverse this in proportion of unsold area. So accordingly, 33% has to be reversed, which is 1 crore rupees. So that is my liability. What about the service tax credit? I have taken this 10 crore rupees service tax credit. Today I have received the OC. Am I liable to reverse? The answer is no. You are not liable to reverse the credit of service tax which you have availed if the OC is received in GST regime. This is for the reason that there was no such similar provision for reversal which is there in GST regime. Service tax law was not drafted in this manner. And again, there are various tribunals and high court judgments which have held that there is no reversal, because at the time of receipt of these services, your intention was to sell the entire unit. Since your intention was to sell the entire units, there will be no reversal liability on you at the time of OC. There was no provision that if the area remain unsold, you have to reverse the credit, because the eligibility has to be seen at the time of receipt of input services, and at that time your intention was to sell the unit. There are various favorable units, and the matter is now pending before Supreme Court, but there is not even a single negative judgment. All 5-6 tribunal judgment, 2 high court judgment, everything is in favor, not even a single negative judgment. But there is an Alembic the Gujarat High Court judgment of Alembic is in Supreme Court, and it is pending before Supreme Court. To my mind, if you are getting OC in GST regime, don't reverse any credit pertaining to service tax. However, any credit which you have taken in GST regime, you have to reverse based on unsold area. Now, what about, like, practically what happens is that in our example, we have received the OC on 31st March 2019, but practically you will receive services even after 31st March 2019. Contractor bill starts coming, etc. So whatever services you are receiving after this date, still you are eligible to take the credit in proportion of sold area. However, at ground level, DGI is disputing it, but it's a very good case to argue that the credit will be available even for the services which are received after OC, in respect of sold area. I think it's already 5 o'clock with this. Now we will end our case studies and move forward towards various question and answer. Thank you. So let me go to the chat box. And Nikita, you there?
Yes, sir.
So let's take question and answer now.
Yes, sir. So, one question is, if nothing is specified in the agreement, developer can collect tax paid by him from landowner? This question is sent to me only, so it's not visible to everyone.
Right. So the question is in respect of an area sharing agreement. Like on allocation of area to the landowner, I have to pay GST. The question is whether developer can collect this GST amount from the landowner if the agreement is silent.
Yes.
Again, it's a very ticklish issue, and there are various jurisprudence on the fact that who has to bear an indirect tax. So if at the time of agreement, I will divide and sum up this in a very simple language. If at the time of agreement, there was already an liability on allocation of this area to the landowner, if there was already a GST or a service tax liability at the time of agreement that this tax is payable, and I have not mentioned anything, then whatever consideration is mentioned, that will be treated as inclusive of GST or service tax. So you will not be in a position to collect separately from the landowner. However, if after an agreement, new levy comes, suppose on this allocation, there is a new levy which is coming, which was not contemplated, then being an indirect tax law, you can always argue that this new levy has to be borne by the recipient. So at the time of JT, if this agreement liability was already there, then it will be difficult to get it from the landowner. However, if it's a new levy, then only you can get it. Practically, we face difficulty in getting this amount from the landowner.
So, next question is there any constitutional exclusion that impediment levy of GST on immovable property?
See, there is no, see that what the constitution says. GST, I will say it in very simple terms, not get into very harsh legal jargons, etc. GST is applicable on sale of goods or supply of services or supply of goods. Goods means movable property, and service has been defined as anything other than goods. So service effectively also include immovable property. So the way law is drafted, constitution is drafted, they are also have the power to levy GST on the transfer of immovable property if there is a service aspect attached to it. Like if you see any builder whosoever is transferring the property to the end customer and they receive advance before the OC, they are paying GST, say 5%, 12% as the case may be. Ultimately, it's also a transaction of transfer of sale of immovable property. So merely because my transaction is of sale of immovable property does not mean that no tax is leviable. There is always a service aspect. And now this in regard to the development rights, can I argue that the sale of development right is nothing but a sale of immovable property and it should not be covered under the GST law constitutionally is very, very gray area. And let's see how courts will come up on this.
Okay, so next question is TDR received in service tax regime, allotment is also done in service tax regime, but OC is received in GST regime, whether GST will be applicable on such transaction?
See, to my mind, there will be no GST implication on this particular transaction. You have the transfer of development right has taken place in service tax regime. That era is over. Allocation has taken place in service tax regime. At that time only, you were supposed to pay the service tax on allocation to the landowner. Since you have not paid at that moment of time, now it's almost time barred. Only last few months notices can be received. Otherwise, any period before that has been time barred. Just because OC is received in GST regime, there will be no tax implication. It's only that whatever credit you have availed in GST, you have to reverse to the extent of unsold unit.
Okay, so next question is please enlighten on redevelopment in Mumbai. So it is specific to Mumbai.
So I think we can skip this question for the moment because again, it's a complete case study which we have to deal in detail. And what we will do is that I will incorporate this particular part in my PPT and share it.
Okay. So next question is, please take 2015 example from the slide on applicability of GST on JDA. So I think it can be seen
So
on.
the answer is
Yeah.
as simple, same as what we discussed for 2010. Since the agreement has been entered in pre-GST regime, there will be no tax on the development right transferred by the landowner to the developer. So whatever revenue which the landowner is getting, there will be no tax liability in the hands of landowner or the land developer. However, for the area allocated, if the construction is undertaken in GST regime and allocation of the area is in GST, then we advise the client to better pay tax on this allocation which is there in GST regime. Otherwise, legally, if you want to argue and take a stand that no tax has to be paid on this area allocation in GST regime, you can take an argument that for this area allocation, the consideration was received in 2015. I should have paid tax at that moment of time, and which is time barred. But we generally avoid this argument. It's highly debatable argument, and you have to fight for this. If the landowner is giving you money, it's not going out of your pocket. Better charge GST and take input tax credit on your construction. Otherwise, this argument is available and it has to be seen on case-to-case basis, agreement-to-agreement basis.
So next question, Bharat Kumar is specifying a case and he's saying that in this case, indirect taxes must be borne by recipient. It was held that. So I think it is particular specific to a case study.
So there are 8 to 10 cases on when a tax liability has to be borne by the recipient and when it will be treated as inclusive of tax. So this is a separate topic in itself and we can discuss this separately.
Okay. Next is whether GST is payable if landowner sells his share of flats before CC or OC. What is the meaning of first occupation that is used in serial number 5B of Schedule 2 of GST Act?
See, the landowner, the area which is allocated by the developer to the landowner, if landowner is further selling this area to the end customer before OCCC, then landowner is supposed to pay GST and collect GST from the customer and pay to the government. Rate of tax will be 5% or 12% as the case may be. There will be a GST liability. With regard to what is the meaning of first occupation, please see our part 1. In part 1, we have discussed in detail what you mean by first occupation. So I will not be repeating for the benefit of all. But in case in part 1, which is accessible at Webtel YouTube channel, we can see the concept and meaning of first occupation in detail.
Next is in case of sale of developed plots, can we say EDC or IDC charges be treated as composite supply?
Yes, to my mind, it's a very good case to say that in case of sale of developed plots, EDC, IDC charges, which I'm recovering from the customer, these are not a separate service in itself. If I would not have been selling the developed plot, I would not have been collecting the EDC and IDC. These are interlinked, and this payment to the government is on the fact that I'm developing these developed plots. So these are interlinked transaction, and to my mind, it can be seen that the amount which I'm collecting is nothing but for sale of developed plot. And if you are paying stamp duty on the entire value, that is 100 rupees is the plot value, 20 rupees is the EDC, IDC. If you are paying stamp duty on your entire 120 rupees, then it's a very good case to say no tax is payable.
So I think all that is all. There are no new questions. And one more thing that more participants are asking for the PPT and for the link of first webinar. So we'll be sharing both the things on your mail ID so you can access that. So Tushar, so there are no more questions. So I think that's all for today.
Thank you, ma'am. Thank you, everyone. Thank you so much.
Thank
if there are any unsolved questions, etc., you can mail them. I will surely come back to you.
Okay, sir. Thank you so much. Thank you for such an insightful session. I think it will be helpful to all. Thank you.
I just hope it was not boring because the topic and case studies was too much. So we have to be little academic because there was so much law involved in today's session.
Yes, sir. Yes, sir. I agree.
Thank you. Thank you, everyone.
Thank you.
Thank you.